Ladies and gentlemen, there's a man who has been on the radar of a few YouTube channels relatively recently. You may remember him as the sovereign citizen who got himself arrested for impersonating a police officer. Now, to be fair to him, he never identifies as a sovereign citizen, despite using some arguments that are very, very similar to ones employed by that group. It's kind of like seeing someone go to Catholic Mass and participate in confession, so although they may not tell you they're Catholic, you have a pretty good idea what their religious beliefs are. Regardless, Schrodingers Cat, a YouTube channel that many of you are familiar with, made a video on this guy with some commentary, and it upset One Stop quite a bit. In his video response to Schrodinger, One Stop claimed Schrodinger did not know what he was talking about, which is where I decided to get involved, because, you see, I happen to know a few things about the law in this situation, and intend to break down One Stop's incident in a manner that will hopefully make sense to him, so he realizes where he went wrong. I've actually tried to explain a few things to One Stop already, but he responds very poorly to anything that contradicts him, which seems to be a major contributing factor to most of his problems. So be sure to play nice in the comments section, folks. Schrodinger started his video at the day of the arrest, but I wanted to back it up a little further and give some background on One Stop and the situation that led to the arrest. First, he's homeless, he lives in an unregistered RV, and struggles to understand the difference between civil and criminal law. On April 1st, 2020, One Stop arrived at his RV, which was parked in the public parking lot of a private business, to find a note had been duct taped to a window. The note told him to take the RV off the property and gave him a timeline to do it. The note was written by a co-owner of the parking lot, and One Stop tried to argue to police on scene that the other co-owner had given him permission to park the RV in the lot over the past 6 months. But since it was only a verbal contract, the argument didn't hold much water. One Stop then tried to turn the police on the co-owner, stating when One Stop had removed the note, the tape damaged his window, and claimed it was destruction of property. Police essentially told him that this was his own fault for not exercising due care in removing the note, and that because the co-owner did not intend for the damage to occur, it wasn't a criminal issue. Pause. It's time to learn. One Stop, many crimes require two things: mens rea, which is the intent to commit a crime, and actus reus, the action that constitutes the crime. Destruction of property in Virginia, the state where this took place, does require a person to, quote, intentionally cause such injury, end quote, meaning mens rea is required for the act to be a crime. Because the mens rea requirement was not met, this appears to be a civil issue. Now, One Stop didn't like being told this and came very close to being charged with disorderly conduct, but that's not really important though. What is important is that we can establish One Stop doesn't know much about civil law, despite claiming to be an attorney, and that he had to find a new place to park his RV. And he did find a new place to park his RV, but it didn't stay there for long. He parked it on a bit of grass, and within 24 hours, it had been towed. What? Surely towing a vehicle is theft, right? Well, One Stop certainly thought so, and has repeatedly argued that the law requires a vehicle to have been parked for 72 hours, or signage must be present stating the area is private before a vehicle can be towed, and that other vehicles were parked there, so they should have been towed too. Stop! It's time to learn. The statute One Stop has repeatedly cited in comments regarding the 72 hours signage says that it is illegal to park on private property without permission. The 72 hours signage is only required if there is a local ordinance requiring it, and the vehicle is in a parking lot that has been designated for public use. This bit of grass does not appear to be a parking lot designated for public use. Additionally, it is up to the property owner's discretion to remove vehicles or allow them to remain. It sure sucks that yours was towed, but you probably should have gotten permission before you parked your RV and walked away. Perhaps you weren't given notice like the other vehicle owners were because their vehicles were registered and yours was still unregistered, which perhaps caused the owner of the property to believe you didn't intend to come back for it. Now, One Stop stated the property he parked on was the government's property, which is true. It belongs to the Halifax County Service Authority, but I'd like to take this moment to remind everyone just because property is owned by the government, that doesn't mean it's open to the public. If it wasn't designated for parking, you don't get to park there. I don't get to park my vehicle inside of a public hospital's lobby and claim I have the right to do it because the public lobby is publicly accessible, right? I hope you're paying attention, One Stop, because you made statements in court that indicate you are definitely not aware of this. He also stated at one point the property was owned by a private corporation, and if he thinks the government is a private corporation, well, there's your sovereign citizen link. And there are a lot of other things he says that are very, very close that we can go over at a different time. Regardless, I think we can safely assume he has no idea what he's talking about. Now, But let's entertain the idea that the tow was wrongful. Even if that was true, this is still a civil issue, as every law enforcement agency, from the local police to the FBI, told him. And yes, he called the FBI repeatedly about this. One Stop believed the police were shirking their responsibilities by not taking this case. But if every agency stated One Stop was trespassing, as One Stop claimed they did, and every agency told him he'd have to address this in civil court, who you believe is more knowledgeable about this situation? The local police, county deputies, state police, or FBI? Or are you going to trust the man who trades marijuana for food while upsetting people in Boulder, Colorado, where he apparently had his gun rights revoked for a year due to harassment? So, after One Stop called every law enforcement agency he could think of, he decided to have a discussion with the property director of the bit of grass One Stop had parked on, a man who apparently used to be One Stop's baseball coach. After a conversation, the former coach called the police to have One Stop trespassed, which doesn't surprise me, since this is how One Stop apparently behaves himself while not upset. So what did he do? He went to a magistrate to file a felony warrant in order to get the owner of the towing company arrested. But the magistrate wasn't having it. One Stop needed an attorney or law enforcement to sign off on the warrant before it was filed. Bummer, right? But One Stop had a trick up his sleeve. In his mind, he is an attorney because he studied law for a weekend, which is not at all how that works. So why couldn't he just approve it himself and go ahead with the process? Well, that's exactly what he apparently did. One Stop devised a legal notice and served it to the owner of the tow company, who looked at it and told One Stop to get off his property. Bam! Trespassed. One Stop did leave, but not before letting the owner know he was under arrest and not free to leave. Bam! Citizen arrested. Except you can't make a citizen's arrest for a civil issue. And since literally everyone was telling One Stop this was a civil issue, he had no excuse for ignorance. Bam! Impersonating an officer by conducting the duties of one without lawful authority. In Virginia, you can only effect a citizen's arrest to stop a misdemeanor breach of the peace and progress, which was not occurring, or to prevent a felony from occurring. Now, One Stop did believe a felony had been committed when his vehicle was towed, but that alleged felony happened days prior, and because it seems unlikely One Stop arrived at the towing company via time machine, he can't exactly stop something from happening that has already happened. Of course, the owner of the tow company called law enforcement, not because he wanted to retaliate like One Stop claimed, but because, hey, a crime was committed in his presence, and county deputies arrived to find One Stop, who had also called deputies to his location to have them enforce the arrest, still in the area. I know, this situation's nuts. And that's when the magic happened. One Stop tells police he's a private attorney general investigating the matter, which is so incredibly absurd, but it gets so much worse. In my back and forth with One Stop, he's tried to explain why he's a private attorney general and cited the Rico Act, or Racketeer, Influenced, and Corrupt Organizations Act, as the law which gives him the ability to act as a private attorney general. I've read the Rico Act, and shockingly, it doesn't do that. It turns out, and I'm not hypothesizing this came directly from One Stop. He used Wikipedia as the source, establishing the theory that the Rico Act grants him that title. All right, let's back up. No, just no. A private citizen acting as a private attorney general is only relevant in a courtroom. Basically, it's a doctrine that allows a citizen to file a lawsuit in which they are the plaintiff and where a ruling in their favor would benefit a large group of people. Some might even say a community, the general public. The only thing they get from this is a waiver for legal fees. It doesn't in any way grant investigative authority. It doesn't allow a person to act as law enforcement. It doesn't allow a person to claim to be an attorney. The Wikipedia article that pairs RICO with private attorney general just uses a RICO crime as an example of when the private attorney general doctrine might become relevant. If he had read the article, he would not only have seen a whole bunch of citation needed, he would also have seen this. Quote, "There is no such thing as a private non-attorney citizen being a private attorney general for all purposes. The term applies only to the exercise of one's ability to pursue certain specific kinds of legal actions which are statutorily authorized. It does not create the ability to call oneself a private attorney general," end quote. Now, interestingly, in my digging into the situation, I discovered that this isn't the only time One Stop has conducted investigations under the fictitious authority of a private attorney general. Not only does a private attorney general not have any investigative authority not available to the public, and not only does the private attorney general doctrine only apply in court, he would still need to be a licensed attorney to act as a private attorney general on someone else's behalf. You can spend up to a year in jail for the unauthorized practice of law in Virginia. Knowing all of this, It's absurd for One Stop to have thought the private attorney general doctrine would apply. Arresting the tow company owner doesn't benefit a community. He could make the argument that every law enforcement agency he's talked to is a corrupt organization conspiring against him, but that's absurd because his issue is a civil one, as they've explained to him, and the police aren't going to get involved in this type of civil issue. Now, as One Stop is explaining this stuff, well, explaining is maybe too strong of a word, the police do eventually stop the stream of nonsense coming from his mouth to once again tell him the things he thinks are crimes aren't. At which point, One Stop tells the officers that the officer is acting as an unlicensed attorney practicing law, which is the crime. And this is especially delicious because that's literally what One Stop is doing and has, by his own admission, done in the past. He also states that the Supreme Court has ruled the sole duty of law enforcement is to take criminal reports, which I'd love to see a citation on. He claims he has the right to have a supervisor present, which I'd love to see evidence of. While being arrested, he tells the deputies he never told the tow company owner he was under arrest, despite telling them earlier he told the tow company owner he was under arrest. And he claims the arrest is witness intimidation, which is absurd. Now, to his credit, there is an interesting thing that One Stop points out. One deputy tells another the paper One Stop served to the tow company owner was a handwritten warrant on which One Stop claimed to be a deputy sheriff. Now, to be fair, that's not entirely accurate, but it doesn't really matter since the arrest wasn't made because One Stop allegedly claimed to be a deputy sheriff. The arrest was made because One Stop served legal paperwork and placed a man under arrest without the authority to do so. It doesn't matter if the paperwork wasn't technically a warrant. It doesn't matter if he claimed to be a deputy sheriff. The actual situation was enough to establish probable cause for an arrest. Now, One Stop has claimed the incorrect statement by the deputy was equivalent to filing a false report and making false statements. No. For that to be a criminal matter, it requires the intent to provide false information. Remember, we talked about mens rea earlier? Great. That deputy had gotten some information wrong, maybe through a game of telephone. And immediately after making his statement, he and the deputy he was talking to reviewed the paperwork One Stop had issued, at which point both deputies would have realized the error of this statement. If that assertion had resurfaced in the police report, yes, then there might be an issue. But once again, One Stop is demonstrating he has no idea what he's talking about. It's pretty simple stuff, right? One Stop illegally parked and has RV towed. Yeah, shocking, I know. He tried to get someone arrested by serving them a warrant a magistrate had told him he could not serve. Bad choice, bud. He conducted a citizen's arrest for what he should have reasonably known was a civil offense, which is definitely not allowed. Look up citizen's arrest before you do one, guy. He claimed to be a lawyer merely because he had studied law for a weekend while telling other people they were breaking the law by trying to practice law without a license, which is absurd. He claimed to be a private attorney general, which doesn't apply here at all. And he served paperwork alleging the tow company owner had committed the crime, then placed the owner under arrest for a civil issue, which is not only not permitted by citizen's arrest laws, it also appears to meet the elements of impersonating a police officer. You get that? Great. Okay, cool. And yet, this guy is confident he has it all figured out. Sure, bud. Good luck with that. If you like this video, be sure to hit that like button. And if it gets enough attention, I'll make a follow-up video breaking down One Stop's response to Schrodinger's Cat video. Or go through the stupid things he said to the FBI. So many stupid things. Subscribe for more like this. And until the next time, be good, stay safe.